Hi, my name is Megan Donahue, and I'm an associate here at Kelly Dry.
Hello, I'm Jenny Wainwright. I'm a senior associate here at Kelly Dry. Today, we're going to be talking about SB 140, a bill that was recently passed by the Texas legislature, which amends how the state's existing telemarketing law applies to text messages. With the changes in effect as of September 1, we've been getting a lot of questions about how the new law is going to affect businesses, particularly those that send marketing text messages to customers in Texas. And today, we're going to talk through some of those frequently asked questions. So SB 140 amends the definition of telephone solicitation in the context of requirements related to telephone solicitor registration and disclosure requirements so that that portion of the law now expressly includes text messages. Before, this section of the telemarketing law only applied to telephone calls, but now it does cover texts. So what that means is that businesses that engage in text marketing have to consider whether they need to file registrations with the Secretary of State and abide by certain disclosure requirements in the law. It's also important to note here that other portions of the telemarketing law as they existed previously already covered text messages. So the change to the definition of telephone solicitation really affects primarily the registration obligation and the accompanying disclosures that go with it. Not directly. The substantive requirements related to quiet hours, consent, and the Texas no-call list did not change with SB 140. But what did change is the enforcement mechanism. SB 140 ties violations of the telemarketing law to the Texas Deceptive Trade Practices Act, which potentially gives consumers a private right to enforce.
Where the DTPA provides a private right of action, consumers can now seek treble damages for willful violations, attorney's fees, and damages for mental anguish. And in another important detail, settling one case doesn't automatically exempt you from future litigation for the same conduct, leading to higher financial and legal risks for companies. While SB 140 doesn't necessarily add new substantive compliance requirements, it does raise the stakes for businesses doing business in Texas and makes it a little bit easier for consumers to file suit. If you're a business engaged in text marketing in Texas, now is the time to review your compliance programs and ensure that you and your partners are complying with SB 140.